Too hot.
This is on all focus, right?
Yes.
Okay. All right, so the camera is rolling.
Okay.
Let me get back to my camera.
You guys ready?
We're ready.
All right, well, good morning, everyone. Thank you for coming today. I just know that I've had a lot of inquiries about the recent Marsy's Law ruling by Judge Williams. Just wanted to provide an opportunity for any of you to ask me any questions about that and how we're handling that and how we will handle it in the future in light of the judge's ruling. And then obviously we also have a First District Court of Appeals case that's on its way to the Florida Supreme Court as well. So trying to get some of these issues resolved, and we have to some degree. And that's a good thing, but I thought I would just open it up to questions and let you guys ask me anything that you may have.
Yeah, I mean, I think the biggest thing that we've seen so far, in your statements that you've released so far has been, that you believe that the deputies have a right to have their names protected. I read all 8 pages or 9 pages of this ruling, and I don't think it seems to dispute that. It more just disputes that, they legally obtained the information and they were allowed to print it.
Right, so this is a finer nuance of the issue of whether it applies to law enforcement. The First District Court of Appeals has already ruled that it applies to law enforcement. The Supreme Court will ultimately decide that, but I think what Judge Williams was trying to resolve here, and what we were trying to get resolved, and this is the only case I'm aware of that has resolved the issue, if there is an inadvertent release of the information, or if there's some other journalistic method by which you get the information, not as a result of the victimization of the officer, is that allowed? And the judge has ruled that it is allowed, and we are not going to take an appeal on that. So that finer issue has been resolved. The larger issue of whether it applies to law enforcement officers will be decided by the Florida Supreme Court. But the language is pretty clear in Marsy's Law that it is all victims. And I would just add to that, as a sheriff's office, we are kind of stuck between a constitutional rock and a constitutional hard place, right? We have the First Amendment, and then we have a constitutional amendment to the Florida Constitution that was voted on by 61% of the citizens of the state of Florida. So at least as to this issue, the inadvertent release, yes, we've got that resolved. Any other questions?
Why specifically did this particular case for you qualify for, to be under Marsy's Law in your perspective?
Sure. So if you read the report of the officer-involved shoot team, they indicated that two of the 3 officers were victims of an aggravated assault, i.e. the knife being, pushed towards them as the person got up from the table. So they are victims of aggravated assault. One of the officers was far enough away that he wasn't within what we would classify as the zone of danger. So we only said that 2 of the officers were victims of an aggravated assault. That is somewhat consistent in these officer-involved shootings, particularly when there's been a weapon or some type of physical confrontation, then the officer would qualify statutorily as a victim, and they did in this case. Now, there may be a scenario where that doesn't work. For instance, there are 2 officers. One officer may be the officer that shoots, and the other officer was the victim who was in close proximity to the suspect. The officer who shot may have been far enough away that they wouldn't have been the victim of an aggravated assault. So just in this scenario, both of them were in a small apartment in close proximity within a matter of feet of a gentleman who stood up and extended his arm with a knife in his hand. So they did qualify as victims of aggravated assault.
And reading the Herald-Tribune report that came out yesterday with all the information, I mean, it does really clear your deputies. It is all good information that they did their jobs and they did what they were supposed to do. Why wouldn't you want that information to come out?
Yeah, that's an excellent question. First of all, with any victim of a crime, law enforcement or not, the privilege attaches to the individual, right? So we're kind of a third party in this, in that we possess the information. But much like a sexual battery victim or a domestic violence victim or a victim of aggravated assault, the privilege attaches to the individual. They chose to opt in. I think that was the right decision based on the fact that they were victims. But there's also privacy concerns in there, in that if we were to release it and violate that privilege, there could be consequences on the sheriff's office. For instance, if you had a domestic violence victim and we just decided we were going to announce who that victim was because they did not waive their privilege, we could have some exposure there as well. So it was kind of a strange position for us to be in when somebody else is exercising the privilege.
But there was public interest in the actions of the officer. Why not err on the side of being transparent and put that information out?
Well, because the Constitution doesn't allow that. Marsy's law is clear that it applies to all victims, and that's what I meant when I said a constitutional rock and a constitutional hard place. My preference, would be to put that out, but the legislature has spoken, and they've not given any exceptions to our ability to release that. In fact, there is one exception in Marsy's law, and that is the criminal defendant, the person who is committing the crime against the victim, is exempt. We can release that information. So, as most of you know, if the legislature intended to make other exceptions in there, they would have put it in there, and they didn't. I would presume that the legislature will go back and take a look at that. I've been told that they may.
Ed, this is something where the state's attorney's office is the one who inadvertently released this information. I mean, like you just said, it could make you liable. If you were to release that information, is the state's attorney's office liable?
Yeah, I guess that's a question that you'll have to ask them, and you'll have to determine whether the folks whose privilege was not waived want to take some particular action. And I will tell you, there was no maliciousness on their part. Obviously, they've got hundreds, if not thousands, of documents related to this case. It could have just as easily been us, and in fact, to be frank with you, there's been times when we've done public records requests for all of you and missed a date of birth or an address or something. It's human error because there are humans that are doing it. So I don't fault them. It just led to this litigation, unfortunately, and it led to the questions of transparency. But it also gives us an opportunity to say that we want to be transparent. I'm personally have different opinions about Marsy's law, but we're going to follow what the law is, and now that the judges ruled as it relates to inadvertent releases, we've got some clarity on that.
Let's revisit a statement that you just made. You said that the deputies were victims of aggravated assault. Does that mean that the other victim, Mr. Evans, or rather the suspect, was charged? Help us clarify that.
Yeah, so what we're looking at is whether or not a criminal act was committed on someone that would, quote unquote, make them a victim under Marsy's law. And when he stood up with the knife and extended it towards them, and including the statement of an independent witness, it would appear that an aggravated assault was perpetrated on 2 of the 3 officers. As I mentioned before, Mr. Evans, unfortunately, this had a very tragic ending, but in Marsy's law, the one exception is the person who perpetrates the crime, that name could be released, and we did release his name because of that.
So it's the act of the aggravated assault and not necessarily the charge of the aggravated assault. Help us clarify.
Well, the individual who committed the aggravated assault is deceased, right? But a criminal act did occur on the officers. So Marsy's law says the victimization and the rights attach at the time of victimization. So when the aggravated assault occurred, that's when Marsy's law privileges attached to those deputies.
If you take the position that deputies can be considered victims while they're performing official duties, what would stop you from withholding information anytime there's any kind of confrontation? Where would you draw the line, and is that your line to draw? Well,
first and foremost, our line is what the law says, right? And Marsy's law says, any victim of crime. So in your scenario, if I made a traffic stop and the person was unruly or disorderly, but I wasn't a victim of a crime, we release those, routinely. But if the officer is punched, kicked, shot, stabbed, hit with something, and is a victim of a criminal offense, then the law is pretty clear that Marsy's law privileges attach.
So if the state attorney's office had not inadvertently not redacted that name on that document, you're saying that we would not be here and they would still be protected based on that?
Yeah, I think that's a good point. I think they still would be protected, and I think that's where the legislature perhaps needs to step in, because if you think about it, much like a sexual battery victim, domestic violence victim, they will forever be protected under Marsy's law. There is no time limits in the law. There are no parameters on that. So yes, I think if the legislature revisits that, they'll probably put some time parameters on those.
So you were aware that this was a First Amendment issue, considering that the paper in question had requested this legally through the
Yes.
public records request. So why then take that step to get the injunction?
So the public records request is separate from Marsy's law, right? The public records request under 11907 has a whole separate set of circumstances than Marsy's law. And frankly, my concern was I was in a position where I had to protect the privilege of the deputies that they had exercised. We had communications with the Herald-Tribune. They were somewhat cut off in that we didn't get a response back after a certain period of time. And my concern was that was going to be released in violation of Marsy's law because we weren't having a good dialogue. So we sought the injunction to call a timeout until we could get a judge to look at it, and that's exactly what happened.
Is there anything else that you wish to add to summarize?
Yeah, I'll just add this. I understand, you know, I'm a citizen too, and I pride myself as a former constitutional law professor many years ago following the law. But we have two laws here. We obviously have the First Amendment rights of the media and the public, and we have a constitutional amendment that was passed by a supermajority of voters. So it really puts us in an awkward position to have to choose one of those, and we chose to get the injunction and have the judge resolve at least this issue about the inadvertent release. And hopefully the Supreme Court will rule shortly, and we'll have some clarity on that as well. So for your viewers, I just want them to know it's not any desire on our part not to be transparent. It's a desire on our part to make sure that we're following the Florida Constitution and our federal Constitution. And unfortunately, those two conflicted in this particular case, and probably will continue until we get some resolution on this. I will tell you that when Marsy's law was enacted, I had a variety of legislators that came to me and sat down, and I told them this was going to be a problematic bill. As good as it was, if you go back and trace the history of Marsy out in California, and her case is a terrible, tragic case, and victims are harassed and have all kinds of bad consequences by the fact that they are a victim. But I explained to the legislators they needed to look at this very carefully. And unfortunately, I don't think they took my advice or some of the other sheriff's advice, and now we have a very strict reading of Marsy's law. Victimization occurs at the time the crime is perpetrated upon you. There are no exceptions to it, except now I suppose we have an exception if there is an inadvertent release, but prior to that, we really had very little case law. The case up in Leon County that went to the First District Court of Appeals and is now on its way to the Florida Supreme Court is really the only Marsy's law case on point that we have to seek any guidance on.
And you'll continue to follow however the Supreme Court rules will be?
Sure,
Yeah.
absolutely. If the Supreme Court rules that it doesn't apply to law enforcement, then we'll take appropriate action. If they do, then I have a feeling all of us will be having a conversation, you know, the next time this happens. And understand, it's not, I've had some people say, well, Sheriff, you could just release the deputies' names and be done with it. It's not that I'm trying to protect the deputies, and frankly, the two deputies involved in this, three, but two in particular, have been solid employees, excellent employees, people with compassion and show empathy. They've worked in areas of this agency where they've helped a lot of people in this community. It's not about trying to protect them, it's just trying to make sure that we don't release something that could then cause a lawsuit on the sheriff's office for inadvertent release.
Let's revisit the incident on April 1st for a
Sure.
second. Have you or are you reviewing your policy, or has this created an opportunity to review your policy in regards to how you carry out evictions? Because people are saying that an eviction should not lead to the death of anyone.
No, it shouldn't, but you would hope that somebody wouldn't pull a knife and assault an officer on an eviction. You know, I've had some folks say, well, Sheriff, why don't you just send civilians in there or send mental health professionals in there? You know, one of the deputies in this case knocked on the door, left a card for the individual. When we went in, we used de-escalation techniques. We used you know, a less lethal opportunity to try to stop the individual. So a lot of that is controlled by what the individual does. It was an eviction, but it could have just as easily been a traffic stop. Could have just as easily been, you know, some other innocuous encounter that the individual decides that they're going to pull a weapon. So, but to your point, yes, we look at all of these cases after the fact. This was a very tight, confined apartment. We went in there with multiple officers. We got a key. We announced ourselves. I don't know, in looking at it, that I could tell you that we would do anything different on the eviction. I know that there were people in that apartment complex that were concerned. So it's not like you could ask, well, the landlord or the manager or somebody to go in there and do our business for us. That's what we do. We put ourselves in harm's way. And frankly, where a lot of other employers their employees might be able to walk away from a scene like that. Our job is to enforce the court order, and we can't just simply say, okay, somebody's not cooperating and walk away. But let me end with this. We recognize the mental health issues that we have in our community and the tragedy of Mr. Evans losing his life. It's a terrible, terrible thing. But I would also point out to you that these deputies have to live with the fact that they took a life as well. And I know several of our deputies who've had to do that struggle with that. It's not something you come to work and expect to do or hope to do. It's just part of the job. But we've looked at it. I don't see how we can do the evictions really any differently. We had additional folks there with us. We had the court order. We announced ourselves. We left our card the day before. My understanding is the deputies were prepared to help this individual get to another location where they could have housing, and we do that all the time. A lot of times we'll give them a little bit of time to get their property out of there. Look, we don't want to throw anybody out on the street, right? It's a traumatic thing, but I guess my point is we never really got a chance to have a dialogue with the gentleman about how can we help you, whether it's mental health services, whether it's a ride to a hotel, things we do all the time. It just escalated very quickly when the deputies went in there. We didn't have an opportunity to explore some of those things.
Thank you.
Sure. Thank you, everybody.